This is number 3, is legal landmines buyers discovered too late. What you will not find in a public records is whether or not the business that you're considering buying has been through an arbitration, or it has been through mediation, a pre-suit mediation, or they have received a letter threatening litigation, or they have sent a letter threatening litigation. None of that is in the public record. So you need to ask the seller to disclose not only the litigation they've had in the last 5 years, but also whether anybody has threatened with litigation in the last 5 years, whether it's an email, a letter, or an attorney letter. That will not show up in the public records. They got to tell you that information. You also got to find out whether they have been a party to any arbitration proceeding, because that will not show up. And I think I touched upon arbitration a few episodes back. In arbitration it's a private court. And one of the most popular ones you've heard is American Arbitration Association. The process is similar to going to court. I'm just using a general example, but in essence, you're hiring a private judge in a private court, quote unquote, which is to administer the process. So in this case, the American Arbitration Association is hired to administer the case. You pay them a fee, and they handle the case management process. An arbitrator is appointed who becomes the de facto judge for that particular case. And they have to be paid separately. That is a separate process. It's a private process that is not shown on the public record. So you got to find that out. Have they paid any settlements as a result of a threat of litigation? That's important to know. And why? Again, there's nothing negative. If there's any type of threat of litigation that could impair you from buying the business, or you might dissuade you from buying it. The point is, you need to know that information so you don't have surprises at the end after you buy that business.